Hello. Good afternoon, everyone, on this dreary day out there. Once more, thank you very much to the Institute for, once in a while you make mistakes, but inviting me to come and talk, that's very kind of you. Ted, that was a very kind introduction. I also appreciate that. So, I've been asked to talk about two things that give me tremendous joy, two things that I really enjoy. The interface of law and how do you make a boatload of money. Okay, so it's a very simple thing. The interface of law and the economy. And the interface of it, from my perspective, is predicated on the issue of intellectual property. So I'm going to talk about that. I think the most interesting part of this kind of dialogue is what happens after I stop talking and where we can have a discussion and I can get your insight and we can all learn from each other as to how you see the issues that I've talked about. So I hope that at the end of my brief set of comments, you will have questions and we can have a more intense discussion about that. So, I'm going to make sure this thing works properly. There we go. So this kind of gives you an idea of where I spend my time, or a series of books I've been reading recently. How many of you are familiar with Yuval Harari? Good. All right. So he's written 3 books. All 3, I think, are actually very thought-provoking, and I've had the pleasure of reading all 3 of them. So I think I have quotes here from 2 of his books. So if you're interested in having someone discuss history from a very unique perspective, I will encourage you to read his books. But one of the things he talks about is this issue of shared myths. And his basic argument is that what has allowed us as a species to distinguish ourselves from other species in the animal kingdom, we are part of the animal kingdom, by the way, sometimes more animal than anything else, but that one of the things that allowed us to do that is the fact that we have the capacity to come up with and to share myths. And it's these myths that knit together our society. So that's one of these basic concepts. So I start off with the issue of shared myths, because one of the shared myths that we have is this idea of intellectual property. We made it up. It doesn't exist. There's no natural law that would justify you protecting the Nike swoosh mark. How does that make sense? How can you protect that among 7 billion people in the world? A check mark. There's no natural law for that. We just made it up. And we made it up from whole cloth, and we called it intellectual property. And we developed a number of concepts around it. So we talk about patents. And they're all species of the same kind of fundamental type of property, which is the product of your mind. So we talk about patents, which tend to protect more technical things. We talk about copyrights that tend to protect things that you fix in a tangible form that is produced from your mind. We talk about trademarks, things that tend to indicate the source and the quality of a particular product. It's an evolution of passing off. We talk about confidential information, trade secrets, and the like. But the bottom line is this. This is part of the shared myth. We made it up. And what is profound about it is that when we start talking about what the economic impact is of what we've just made up, it blows my mind, and I don't know whether it will blow yours. Another shared myth, since I used in the title that intellectual property is the new global currency, another shared myth is the idea of currency. We made it up. In the early days, the original forms of currency was actually something useful. Barley, for example, was currency for a long time. You could actually eat it. So that kind of made sense. But we quickly moved away from that. And today, in terms of M1 within our system in the US, only 8% of the liquidity that we have is physical cash. The rest, a bunch of digits on a computer somewhere. And yet, People live, people die because of this. We just made it up. Another wonderful shared myth, which we call currency. But it's useful because, it moves you away from bartering to a more fluid way of doing business. And over time, we've all bought into the myth. We got off the gold standard decades ago. So the piece of paper in your pocket is nothing but an illusion. Actually, it is the ultimate con game. After all, the whole point of the phrase con game is that it's a confidence game. And you have a confidence person. So your currency, our currency, any currency is a con game, but a very efficient one. And that is part of the shared myth. Again, wars are fought over this. People die because of this. But it's a shared myth. It doesn't exist, but it works for us because we made it up. All right. So I use the phrase that is the new global currency, but actually it has a very interesting antecedent, a very old antecedent. I'm going to talk mainly from the US perspective. This is an interesting thing when you look at it from other countries' perspective because it's a slightly different view. But from the US perspective, we started our own concept of intellectual property out of the UK. All right? So it's worthwhile thinking about what happened in the UK. It goes all the way back to 1623, 1624, so it's somewhat dated. But the concept at that time, and I'm talking here about patent law because it's one of the easiest to understand, but the concept here was essentially that you had a sovereign, you had several sovereigns that created monopolies, or what is sometimes referred to as the common law monopoly. And there's a distinction between that. By the way, there have been reams and reams and reams of books written about whether or not a patent is a monopoly. I think it's sophistry at its worst. It is a monopoly, but it's a government-sanctioned monopoly. But there have been reams written, and the big distinction is this, that there is something that is known as the common law monopoly, where you take something that is in the public domain out of the public domain into the private domain. And that is considered really, really odious. So what did the sovereigns used to do in England? When they went broke, after they borrowed money from people, they couldn't figure out how to pay them back. So they would do some really silly things. Oh, there you go. I'm going to give you the right to be the sole person to supply salt in Manchester. Well, hey, everybody's already using salt. And all of a sudden, you get the unique right to be the sole person to supply salt in Manchester. That is considered a common law monopoly. You took something that was in the public domain and you put it in the private domain. So long story short, Parliament got all bent out of shape about this. And in 1623, they decided they were going to do something about it. And what was the brilliant idea? They were going to stop the sovereign from having the right to grant monopolies. And of course, being Parliament, what did they do with that right? They took it for themselves. and Parliament now became the basis of granting letters, patent, and other monopolies. So in effect, from the very beginning, the whole concept of intellectual property, particularly in the case of patents, but I'd say this applies to across the board, all forms of intellectual property, has always been tied very strongly to money, to economics, to making money. It's always been about that from the very, very beginning. And it's interesting, just to put this into perspective, the way the Statute of Monopoly was originally drafted, particular Chapter 6 of it, it actually gave protection to the first person who imported technology into the realm, being England. So guess what that meant? He actually gave protection to those who were smugglers. He gave protection to thieves. Because at that time, the Low Countries, Italy, the Netherlands, they were the ones that were technologically advanced vis-a-vis the UK. And what the UK wanted was to get technology to come into the UK. So they passed a lovely law that said, if you steal it and you smuggle it in, at the pain of death, by the way, if they caught you, you were dead, we will give you protection. So when people bellyache about China and India nowadays, I chuckle. Check your history. By the way, we did the same thing in the States. So, you know. Anyway, long story short, from the very beginning, intellectual property has been about money, it's been about economics, and it's been about using a monopoly power to engender that kind of economic success. In the US, ours is even a more unique type of intellectual property antecedent. Yes, we copied England. Yes, the folks who were around the table, many of them came from England. But ours is even more unique because we put it into the Constitution. So think about it. In the summer of 1787, with all the issues that this country was dealing with, in terms of forming a whole new government, a whole new concept, why in the world were we talking about intellectual property? I tell my students, it's like opening the tomb of King Tut and finding a cell phone in his hand. Why was it in 1787 that we were talking about intellectual property? Not only were we talking about it, there were two separate submissions for that provision in the Constitution. So not only were we talking about, we were excited about it. We were engaged about it. This is 1787. And it's interesting because we put it in the very beginning of the Constitution. So it's Article 1, Section 8. There was, at that time, no other country in the world that had, as part of its constitution, a provision that formed the basis for intellectual property protection, except the United States. An absolute brilliant move. Because guess what? That has now become the basis of the global economy. And we figured that out in 1787. Now, think about the folks around the table. You had Benjamin Franklin. You had Jefferson, who, by the way, ended up, it wasn't around the table, but he ended up becoming the first head of the US Patent Office. And he himself was an inventor. So you had a number of individuals who understood that direct correlation between intellectual property and bucks, money, economic. And that was understood from the very, very beginning. Very, very fascinating perspective on this. And I gave you a couple of, and then the other big change that we did in the States, again, this is unique to the US, it's not necessarily the same in other parts of the world, is that we decided that it was a form of property. Now, why is that important? The minute you classify it as property, you have all the normal rights that accrue to property. You can't take it away, you can't have the government take it away, you have all the concerns that you have around property. So we made something up, and then we gave it the power of property. And that is how we ended up with the issue of intellectual property. And I gave a couple of quotes here. Those are all Supreme Court or jurist comments about the value proposition that the intellectual property represents. A patent for an invention is as much property as a patent for land. Really? Something we made up is as valuable as land? The answer is yeah, according to the US Supreme Court. There's nothing which may more rightfully be called property than the creation of an individual brain. Really? And the best proof of ownership is that if this man had not thought this individual, and I substitute men and women, had not thought this individual thought, it would not exist. So America took this thing to a completely different level. We understood the correlation between intellectual property and economic progress, and we gave it the elements of property. The French also made a big deal about the product of the man's mind is a high-quality property. So this perspective that started in 1787 has carried through all to today. I mean, in a period right now where there's partisan views about everything, about the only thing that the justices of the Supreme Court seem to agree with, without any correlation to their original political position, is the protection and the value proposition that intellectual property represents. So here's Justice Kagan, who some would consider a liberal justice. In a case that involved Monsanto, how many people know this story, the Bowman story? Okay, great. So a couple of folks know it. In a nutshell, it's a fascinating case. Monsanto manufactures Roundup, which is a very effective product to kill weeds. If you kill weeds in an agricultural setting, you improve your yield. If you improve your yield, you make more money. So it's a good thing to kill weeds. The problem is that most of the weed killers kill not just weeds, they kill everything. So all of a sudden they're killing your crop. That's not a good thing. So Monsanto came up with a very brilliant idea. What if we make certain seeds for our crop and we genetically modify the seeds in such a way that they are resistant to what we sell, which is the weed killer. And they did that. And so if you bought a Monsanto seed, you would have a better yield because you could spray your whole field with weed killer without worrying that it's going to kill your crop. Makes perfect sense. So the yields go up, and those who buy it make more money. But Monsanto decided that, you know what, we are going to have a different business model for how we're going to monetize this intellectual property. And what they decided to do was not to sell you the seeds. What Monsanto did was that the fine print said that they licensed the seeds to you. Well, if I'm licensing the seed to you, that means that I can put restrictions on my license agreement. If I'm selling the seed to you, then there's a question of whether or not I have an exhaustion situation and you own the seeds. So Bowman was a farmer, and of course, two other things you should know, just to make before the judgment makes sense. Monsanto, because they want to make money, engineered their seeds to be sterile after the first planting. So you couldn't do what farmers have done for thousands of years, which is I harvest some seeds, I keep it for the next planting, and I plant what I have. So, and not only did they make it that way, but they put it into the license agreement that you could not use it more than once. So, what happens? Bowman is a farmer. He doesn't want to pay Monsanto the high fees for their seeds. And he goes off and he realizes something really cool, that there was some arbitrage opportunity. And the arbitrage opportunity was that Monsanto sold seeds to grain elevators, where you could go and buy grains for animal feed. And he was convinced that in that grain elevator, they would by nature have some grains that were of the bioengineered version. So he goes to the grain elevator where you sell seeds for animal feed, and he bought some of that seed and he planted it. And lo and behold, he was right. In the mix of the seeds that he bought were the genetically modified seeds. So Monsanto and all the major seed companies go around the country they hire people to go and spy on farmers to make sure that they're not using their seeds wrongly. And they sued him. And this case goes all the way to the Supreme Court. And he's like, wait a minute, I bought the seeds. There was an exhaustion concept in contract. I bought it, done, I own it. Whatever I do with it is no concern of theirs. He loses the case. And this is Justice Kagan's, who wrote by the way, she wrote the judgment for a unanimous court. If Bowman was granted the exemption, that is to say that this exhaustion has applied, patents on seeds would retain little value. Further, applying the normal rule will allow farmers to make effective use of the patented seeds. Wait a minute. Justice Kagan believes, representing the unanimous decision of the United States Supreme Court, that the job of the court and the system is to enable those who have patents to make money. Right? That's what she said. We shouldn't use the normal rules. If we use the normal rules, farmers are going to make money. And those who have the patents won't make money. This is horrible. This is someone that is considered a liberal judge. Okay? Unanimous decision. Our most quiet justice, Justice Thomas, he also gave an opinion on intellectual property in the Myriad Genetics case. And again, a fascinating case. But he makes a distinction that if you talk to a lot of scientists, they say the distinction is meaningless. But he makes a distinction that in effect, in many regards, allows a form, depending on how you structure it, a form of patent protection for some DNA strands. So here you have someone that is considered a liberal judge and someone that is considered a conservative judge, all kind of agreeing that the protection of intellectual property for the purpose of making money is a very, very good thing. So 1787 to the current day, we have the same perspective. So IP is all around us, right? And this shows you, think about it, 2 or 3 levels of IP. You're looking at brands, which is a form of IP, trademarks and the like. You're thinking of the value of those brands, reflecting the value of the underlying technology that they represent in terms of the products that they sell. And, of course, it has a significant economic impact. And you notice it's across the board, everything from technology to pharmaceuticals to household goods to music. Everything that you are thinking about is in some form or the other protected by some form of intellectual property. So let's think about some of the easiest forms of intellectual property. Let's think of a trademark. I mean, isn't this ridiculous? So the value of the Google brand is over $300 billion. B as in butter for a trademark and a brand, right? Talk less of the underlying technology that is there. Apple, over $300 billion. So you can see that the economic impact of intellectual property rights is tremendous, even when you think about the one that is the least difficult to create, which is a brand. And I always go back to the swish mark for Nike. So the assertion of these rights is actually quite interesting. I love these cartoons. Again, it shows you where I spend my time. Reynolds will now own all rights to your image. You'll have to pony up $100 to the company every time you look in the mirror. Right? It seems funny. How far are we from this? So why should this assertion, why should this value proposition that intellectual property rights represent, why should it matter? Okay? And I want to emphasize that these are just 4 examples, right? I can talk ad nauseum about this, but these are just 4 examples of why it should matter. Why should it matter to everyone in this room, the issues that we're talking about? The first one is that if you look at the US economy, I'm a dollars and cents guy, $6 trillion was contributed to our economy from knowledge-based or knowledge-intense industries in 2016. Represents 38.2% of our GDP. So this is a significant component of our economic activity within the country. It's also led to a material concentration in terms of what is happening to our food source, particularly when it comes to seeds. And the only reason that concentration can exist is because of intellectual property. It also contributes to something that is increasingly not a pipe dream. The whole idea of what is happening in the pharmaceutical world, in the life sciences. And I'll just give one example that hopefully everyone finds intriguing, the whole question of life extension. Okay? This is not science fiction, it's actually science fact, and it's fascinating what is going on there. And again, all of this is possible and is driven and is funded primarily because of some form of intellectual property protection. You wouldn't do it otherwise. And it also has an impact as to the shape and the structure of our economies. Because if intellectual property is truly the new global currency, then you have to start thinking about how do I create the mint to produce that currency. And that will have an impact on the shape and the structure of your economy. So, this is a set of 2 or 3 slides that just shows the economic impact. There we are in the States on the top end of that in terms of This is the US. So when it comes to high technology manufacturing industries, we are number one. Keep an eye on this orange, this pinkish line. Guess which country that is? China. We are number one. Yippee! Look at that. Look at the shape of the curve. No one has quite told China that they're not number one. So they somehow think that they're number one, and they're trying to get there. When it comes to knowledge-intense industries, in terms of service industries, again, we are number one. Really good. But look at this. When it comes to the mid-level high-tech industries, who's that? That's China. Coming right up our tailpipe. So the reality now is that, yes, intellectual property is the new global currency. Yes, it's an important tool to create economic activity. But guess what? Everyone has figured that out. And everybody is working along those lines. And we have to start asking ourselves, how are we going to compete? Let's look at it. So we've taken a look at it on a global level, looking at a couple of countries. But let's come back to the States. And let's look at it in terms of what is done in terms of the market capitalization of publicly traded companies. Isn't that wild? Right now, most publicly traded companies, 80% plus of their value, of their balance sheet, is intellectual property. So you might think that you are investing in a GE with equipment, bring good things to life. But actually, you're just investing in an IP company. And most of your publicly traded companies, this is the reality of it. There's virtually very little physical assets. What is driving their value is pure IP. So how can you be a hotshot corporate lawyer and not understand this? If you go and look at most of the bankruptcies that are going on right now, you know what the main asset is? IP. How can you be a hotshot tax lawyer and not understand this? This is what is driving the economy right now. And we need to start understanding this. One of the most amazing things about intellectual property is that it's ubiquitous. It snuck up on us. And we turned around one day, and this was our economy. Okay, let's look at a couple of companies. So this is a subset. So I've done the international, I've done the national, just looking at the whole market. And now I'm giving you a subset of that. Look at these companies. And I would urge you, pick any company, do the analysis, you're going to get a similar picture. Where the bulk of it is IP. But not only is it the bulk of it, it is the most active value driver. You notice? Look, it's the most active. Most of the activity is not here, in terms of what is driving the value of these companies. Most of the activities is here. So it's what drives the value, up or down, of most publicly traded companies. I talked about seeds early on. I said why you should care. Right now, in the States, 4 companies control 60% of all seeds. When you break that down into subsets, into soy and corn, you've got 4 companies controlling 80% of all your corn. The only reason they could do it is because they have intellectual property protection. So this is what is driving our society. This is what is driving our food supply. Our food supply. For the whole country. There are 10 companies, again, that control the vast majority of the consumer brands. How can they do it? Because they have intellectual property. Every form of intellectual property, from patents to trademarks to copyright to their logos, That is what is driving economic prosperity, and that is what is leading to a huge concentration of power. So no wonder that the Supreme Court of the United States, irrespective of political leanings, all have a consensus ad idem that intellectual property should be protected, and should be protected in favor of those who have it. I should tell you, my business is intellectual property. So I'm very happy. But I think we need to start asking ourselves the question, are there limits? Should there be limits? Are there issues we should be thinking about? My second Harari quote, and this is from his second book, Homo Deus. The title is intriguing enough. We humans become gods. If you want to read it, read it. But it's an interesting book. And it makes a comment that medicine is undergoing a tremendous conceptual revolution. 20th century medicine aimed to heal the sick. 21st century medicine is increasingly aimed to upgrade the healthy. Nice quote. Subtext. Subtext. For those who can afford it. For those who can afford it. All right? So, what does it mean in a practical sense? Penn is the third or fourth largest recipient of NIH funding. We are at the bleeding edge of science. And one of the things that we do really, really good are the life sciences. So a week or so ago, Penn did another first. We were the first to set up a relationship with J&J to set up something known as a J-Pod, which is a wonderful collaboration. And during the presentation, there were 7 companies that came to pitch to try to get people to support them and provide funding for their initiatives. And one of the companies is this amazing little company called Near. And what Near, what they came to talk about is that a lot of PTSD is out there, a lot of brain damage because of all the wars that we've been having. And they've gotten funding from DARPA, which is the US government military research group, and they are working on trying to deal with brain damage and the like. And wonderful presentation. And I think 99.9% of people in the room really got emotional. This is a great thing. They're trying to help veterans who have had all these challenges. But because I'm a dollars and cents IP guy, this is what caught my eye, the fine print. I have enlarged it. In their slide, here was the fine print. Near's technology can one day be used to improve memory in healthy human beings who are aging as well, and has the potential to increase human intelligence. They wrote a paper on that. So back to Harari's comment that 20th century was focused on healing the sick, and 21st century was on enhancing the healthy. Many times, the way you start with your enhancement is by trying to treat a condition. So they're getting funded. I'm in full support of this company. I think it's great what they're doing to deal with people with traumatic brain injury and the like. But at the end of the day, where they're probably going to make the bulk of their money is in this footnote. Think about it. If you can have an implant, like think of it as a USB stick in your mind. And you have the capacity to download information and access that information. Cool? So you come to Penn Law. So Dean Ruger, how are you going to deal with this? You got an entry class of 250 kids. 50 of them have the enhancement. 200 of them do not. Come compete in class and show how good you are. This is not theory. This is happening right now. And this is possible because they have a way of protecting their inventions. Now, I'm going to bring a question up later on. keep that in mind because it raises a very interesting dollars and cents question. Why does a mole rat live 30 years, but a mouse only 3? So, Dr. Cynthia Kenyon is a bit of a legend. She was one of the first to kind of figure out that you could manipulate certain genes and extend the life of certain creatures. She started with little worms. And it was revolutionary, what she did. Well, the upshot of it is that in 2014, a little company was started called Calico. How many people have heard of Calico? Goody gumdrops, only 2 of you. You're going to live long. You figure it out. And Calico is a fascinating company. You know why they're particularly fascinating? Remember I said I'm a dollars and cents guy? This is a private company that has $2.5 billion invested in it. Let me repeat that. This is a private company that has $2.5 billion invested in it from 2 shareholders. Alphabet, the parent of Google, and AbbVie, the pharmaceutical company. My mother's people say that when you see bats in the afternoon, you have to ask yourself what is chasing them. These are nocturnal animals, right? So if you see a bat in the afternoon, there's something really weird going on. Why will 2 shareholders, 2 sophisticated companies, put $2.5 billion into a private company? What the heck are they doing? I'll tell you what they're doing. This is on their website. They're tackling aging. And their aim is to do what? Understand the biology that controls lifespan. This is not theory. This is happening as we speak. And Dr. Kenyon is their chief scientific officer. $2.5 billion. That's a lot of money. And they are absolutely determined to treat aging like a disease. And once you conceptualize the idea that it's a disease, it kind of makes sense for you to cure the disease. And this is what they're working on right now. Do you honestly think that this is something that they're doing for the good of humanity, per se? Dollars and cents. They're doing it as a business. Even more direct, Yoon, who's a physician and a hedge fund manager, funds a little prize in Silicon Valley, $1 million. $1 million. You show me that you have somehow had an impact, a positive impact on extending life and restoring youth, I'll give you $1 million. So pause for a moment and think. The average lifespan in this country right now for men is 78. We're kind of silly. We kill ourselves much earlier. And for women, it's 79. The most dangerous word in the English language is the word average, because that's the average. If you adjust that by zip code, the numbers become ridiculous. In some zip codes, the average is 85. In other zip codes, the average is close to 50. Guess which zip codes are those? So, if the average lifespan increases to 100 years, what does that mean? When do you get married? What? You're going to be married for 70 years? Really? When do you retire? How do you manage your economics so that you can survive after you quote-unquote retire? What happens to your birth rate? The whole of our society as we know it will fundamentally change. Well, these guys are working on making that happen. And, drum roll please, do you honestly think that it's going to be something that everyone can afford? So it does matter that intellectual property is the new global currency. It has consequences real-life consequences. And we, in my view, are not thinking about these consequences as deeply as we should. So, is this where we're heading? I like that, but according to my analysis, all future ideas are already covered by overgeneral patents. Our best strategy is to get out of this business and become trademark infringement lawyers. I don't know how to be a lawyer. That only matters if you take cases on a contingent basis. All right? But is that where we are going? This also shows you where I spend my time, in a Chinese restaurant. This is a Chinese fortune cookie, by the way. I think there's an imperative for us to reflect on where we are and where we are going. It would seem to me that whatever is sufficient to get us to this point is insufficient to get us further. I don't know what the lucky numbers are. So, the race to build this mint, if intellectual property is truly the new global currency, then there's naturally a race to build the mint, to build the best generator of the new global currency. As I showed you in some earlier slides, we're doing quite well, but we're not the only ones in the game. And this is a very interesting comment by the National Science Board. This is the US National Science Board that says, you know what? History, in this case, is not prelude. It's difficult to preclude a simple projection of past trends into the future. So we're doing really, really great, historically, and kind of now, but that does not necessarily mean that will be the case. I just give just one other example. Just, again, I'm not picking on China or India or anywhere else. I just want to give a context to this. China has decided that they want to be the biggest players in AI, in artificial intelligence. And they're investing heavily into that. But the weird thing about having a communist political system and a capitalist economy, something that I was told is impossible to have when I was at London School of Economics a couple of decades ago, the problem with that, and I use the word problem from an American perspective, is that you can direct development. That's both good and bad. They've decided that they want to be the biggest players in the AI space, and that they want to be the world's premier AI Innovator Center by 2030. That's around the corner. And they have put a fair amount of money into play. They've invested more in AI than we have. So if we're going to build the mint, that competition is really intense. So, a global perspective, again, this is the National Science Foundation of the US. You can read it all, but the most important part is this. The traditional center for intellectual property development and creation has been the United States, Western Europe, and Japan. However, the landscape is now increasingly multipolar. That's a nice buzzword for saying everyone is up our tail. And this is real. This is happening right now. Can anyone explain what this is? Who knows this story? Okay, tell us. What's the story?
There was a man who had a cell phone, and the monkey took the cell phone and took the photo of himself, and then was claiming to have the right to the picture. The court said that it's not a valid use of the IP laws.
In whose favor?
In the monkey's favor. They didn't say that the monkey owned the picture, but they said that the man did not.
Actually, they settled the case, and then the Ninth Circuit got so pissed about the case that they gave a judgment after the case had been settled between the players. And the essence of it, by the way, good comment. The essence of it was this. This is a Macau. A photographer leaves his equipment in the forest, sets up to take pictures. The Macau goes and takes a selfie. The photographer goes, retrieves his equipment, and does a wonderful publication of all these great pictures of this Macau that took a selfie. Peter brought a lawsuit on behalf of the Macau to say that the photographer does not own the copyright to the pictures, that the Macau does. Now, here's the interesting thing about that whole case. So, they settled. Maybe they bought some bananas and gave the Macau. I don't know, but they settled the case. But the Ninth Circuit was very upset and gave a judgment that pretty much said what Peter did was nonsense, that the copyright laws in the United States actually use the word human in them, and therefore, obviously, it didn't cover the Macau. And that it's ridiculous that Peter would ever think that an animal will have rights. Here's what is interesting about that. In 2012, here's what is interesting. The Ninth Circuit made a fundamental assumption. The assumption being that the laws only apply to humans, and of course that makes sense because we are the only sentient beings. That logic holds up until you question whether or not we're the only sentient beings. And there's a Cambridge Declaration of Consciousness in 2012 that was done at Cambridge University that defines consciousness and being sentient broadly enough to cover animals. So, as science develops, are we going to stretch that concept of intellectual property protection? Are we going to squeeze it? Are we going to do what Peter wanted? Are we going to say non-human sentient beings are also subject to intellectual property protection? That should be interesting. And the consequences will be quite profound. And the bottom line is this. I think we continue to try to use 17th, 18th, 19th century concepts and apply to the 24th century science. And at one stage, I'm not quite sure you can put new wine into old bags. So, hopefully, at least I've raised the prospect of the assumption that I made at the beginning, which is that intellectual property is the new global currency. More than glad for people to argue with me that I'm full of it and it's dripping out of my ears, but I'm more than glad to have that discussion. There's no doubt that IP has formed the basis of almost every business that we're engaged in right now. This is what is driving our economy. And that is a fact. But I ask the question, I make a living from IP. I make a living from creating and monetizing IP. So I love IP. But I ask the question, should we be drawing a line somewhere between the economic benefits of IP protection and ethical considerations? There was an old film called Repo Man. Has anyone ever, Forrest Whitaker, anyone ever watch Repo Man? And this is back to my issue about economic models. So, remember that slide that I showed of the brain implant to help PTSD and blah, 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 blah? And I said, oh, and the subtext of it is that they could use this to enhance the lives and the intelligence of healthy people. What if they decide to do what Monsanto has done with seeds? So they don't sell you the implant, they lease it to you. What happens when you don't pay for your lease? I presume they have the right to come and repossess their property. And if that happens to be implanted in your brain, they have the right to pull it out. Right? That's what our system says. What if it's a heart? What if it's an artificial heart? You don't pay. There's nothing that restricts the business model that they can use. Monsanto has shown that. The Bowman case shows it. And what if that business model is exactly what happens with seeds? These are issues we need to start thinking about. Should all things that satisfy our current parameters of IP law be subject to private ownership? In my class, I ask my students, it's always a trick question, and I see some of my former students in the audience. I always ask them, should everything be subject to ownership? And it's always very interesting, because a lot of people say, yeah, of course. And then you get one or two people that say, no. And then people say, well, this is a silly question, because you don't own the air. I said, you want to bet? Talk to a bunch of real estate lawyers about air rights. Of course you own the air. We have carbon exchanges. I can pay to pollute. Of course, there's a way to monetize the air. And then we don't own water. I said, what? Have you been reading the news? I mean, water rights are being bought by private companies all over the world. So the question again, is there anything that should not be subject to private ownership? And what should be the business model for life-saving food and IP? I think the upshot of it is that intellectual property is an asset class that we need to better understand. And when you think about the value proposition that Penn Law represents, one of the many value propositions that Penn Law represents, is this idea of a multidisciplinary approach. This whole institute and this talk, it's about that connection between intellectual property and the economy. And I think these are the kind of issues we need to start grappling with. Thank you very much for your time. Any questions? Yes, sir.
Yeah, thank you very much, first of all. It was a great input. I'm an antitrust lawyer from Germany. I'm an airline as well, in the class of 2019. And I have a question concerning, since you are in entrepreneurship and you have focused on startups as well. I'm writing my business case right now. I hope to be finished by the end of December. And one of my main concerns is that I build a product which is patentable, but if I do the market analysis and structural analysis, my greatest concern is fast followers. And you will definitely be familiar with the concept of building a minimum viable product and bring it to market. So what do you think? What is your general advice if you say you have a product which is highly innovative and you bring it to market? Would you say patent first and then bring it to market? Or save your capital, build a minimum viable product, and then see how the reaction is, and then patent it?
Well, listen, it's a great question. There are multiple levels in which it can be answered. So let me try to limit it to 3 levels, okay? The first one, I have a bias. And my bias is that the business that I'm involved in, the private equity business I'm involved in, everything we invest in must have some form of intellectual property protection. So my bias is always in favor of getting some form of intellectual property protection because that's what allows you to make money. Okay? So that's my first point. The second point, I always tell people that one of the first slides that I showed was a synopsis of certain types of intellectual property protection, right? Patents, copyright, trademark, okay. The reason I always use that slide, and the reason I talk about that first, is that I urge everyone, don't have a default, an automatic knee-jerk default to patents. Every time you have something that you're creating that is of value, you should ask yourself the question, strategically, what is the best form of intellectual property that I should use on this? And it's not always, let's get a patent, even if you could get a patent. And the reason that is important is that if you pause for a moment and think about one of the most successful, from an economic perspective, trade secrets in the world is the Coca-Cola formula. If it had been patented, there would be no Coca-Cola today. The patent would have expired over a century ago. Right? The reason it's still generating obscene value And the reason that when you go all over the world, most people miss this. When you see a Coca-Cola factory, there's always a word that people miss. It's Coca-Cola something factory. What is the something? Huh? Bottling, absolutely. Because all they're doing is bottling it. All the formula comes from Atlanta. So sometimes you need to pause and say to yourself, is this something that is subject to reverse engineering? If the answer is no, then maybe the pattern is not the right way to go. If it is subject to reverse engineering, then maybe the pattern is the right way to go. So you need to think about it. You need to think through it strategically so that you make an informed decision. And the third and final thing I would say is this. You're always going to have competition. It's inevitable. So I spend a lot of time figuring out how much money I can make, not how much money someone else is going to make off my tail. And the question is, you keep on climbing that tree. So clearly, you will seek patent some form of intellectual protection. But I would not dissipate too much energy on worrying about fast followers. Do your strategy, think it through, implement it, and build the best product you can. And the minute you are issuing out your product, think about the next follow-up product you're going to do. Yes, sir.
So thank you. And among the interesting kind of quandaries you raised are the kind of macro societal ethics point about should we make this property and should we prioritize making money through intellectual property. One of the things governments all the way back to the England in the 17th century that you described have tried to prioritize is innovation. And I guess would you speak a bit more about devices other than intellectual property that either in theory or in historical practice have worked also well to spur innovation? And you mentioned the guy in Palo Alto who has the Innovation Prize, which is not an intellectual property device. Presumably that could be awarded to somebody who didn't have a patent, right? So I'm just wondering if we, in a world where, say, life-saving medicines, where we have problems with a patent system, social and ethical problems, what other tools might the government or society have to spur innovation?
So it's a two-pronged question, actually. There is a question of what government might do to intervene, to spawn innovation. And then there's what people do, how people react to that, and what they do. One of the most shocking stories that happened in the States, let me talk about something relatively modern. How many people are familiar with the Human Genome Company, Human Genome Program, and there was a company set up? Right, okay. So there was this race to sequence the human genome. And there was a government effort, and there was a private sector effort, and they were really going at it. And at the end of the race, President Clinton hosts a press conference and kind of says, we're going to make all this available to the public. Now, the company, one of my former companies that I've been involved with was SmithKline Beecham. We had spent a boatload of money in the Human Genome Company because they were generating a whole bunch of patents and that kind of thing. And a lot of people lost a lot of money because what was perceived as valuable, the US government intervened and said it was going to be available to the whole public. So government, when it comes to spurring innovation, because I'm a committed capitalist, I have a bias, and I say 99.9% of people do things because it makes sense for them economically. I get very nervous when people don't have an economic interest. But I understand that because that's why you do charities, that's why you do other things, where it's not a question of you're going to make money out of it. It's because you believe in a particular cause. But the vast majority of people do things because of economic interest. And I think that the role of government in spurring innovation is to fund that economic interest. So, two examples. Think about it. When President Kennedy gave that famous speech about us sending a man to the moon and bringing him back safely within a decade, there was no NASA. No one had a clue on how to do it. Not a clue. But the government spent a chunk of money making it happen. It spurred a boatload of innovation, and that innovation ultimately got into the private sector. So government can intervene in that manner, which is just spend money, I want to make this happen, and it happens. But the perpetual motion machine, I tend to believe that the economic system kicks in, and that's what keeps on driving it. Yes, sir.
So my question is, there are a number of areas in intellectual property where a common good is provided, such as open software, where developers can freely contribute to the software framework. So my question is, at what point does ownership cross out of the common realm into private realm when a private entity begins to add features and functionality to that common framework? And in particular, I'm thinking about Google's migration of Android software, utilizing the open software Linux platform, but ultimately going out of that into Android. So at what point do you tip and can you defend this as being private property that Google or Alphabet has contributed sufficient value to make the claim that they own?
The beautiful thing is that those are questions of fact that drive the whole issue of what form of intellectual property you are trying to seek. So if you are going to seek a patent, then, and in the US, we're one of the few countries that actually allows you to have a patent for software in certain circumstances, you will have an interesting conversation with the examiner. And between you and the examiner, you will determine whether or not you have contributed enough to get to satisfy 101 in terms of an inventive step and all the things that you need to get your patent. So those are fact-driven elements. But you are right. I mean, look, no one that invents, let me rephrase that, few people that invent things are doing it from scratch. Many of them are, on the shoulders of others. And in fact, one of the peculiarities of the US patent system, it's a very peculiar system, is that we've evolved. I will save you the boring history, but we've evolved to a point where now we believe that a 20-year government-sanctioned absolute monopoly within the parameters of the claims of your patent is justified 100% on just full disclosure. So what do I mean by that? It's a very peculiar thing. The patent system in the US, and particularly the patent system in the US, is not a right for you to do anything. It's a right for you to prevent others from doing something. So we've evolved out of a situation where there's an affirmative obligation on you to work your patent. We used to have that, we no longer have that. So in theory, you could come up with the cure for cancer and decide not to develop it yourself and not to license anyone to develop it. And you could do that for 20 years. And that's perfectly legal in America. Most parts of the world, you cannot do that. Right? So it's an interesting perspective. You could buy the Mona Lisa in America and you could burn it. It's a commercial transaction. In most parts of the world, you couldn't do that. There will be a public order that says you cannot destroy a historical piece of art. So there are interesting parameters that we put around intellectual property. Can we have two, please? Yes, sir? In the academic and professional world, there are massive debates on the question of the duration of each form of intellectual property protection, all right? And economists wrestle with it. What is the value proposition? So it's a lengthy answer, if you want to, but the point in issue is that, think about it. We had patents originally for 7 years. And the reason it was 7, then we had it for 14 years. And the reason it was 7 and 14 was that was the period of apprenticeship in old Europe. So you would be an apprentice for 7 years, at the end of which you are considered to be skilled enough in the art. So it gave the inventor an ability to have 2 classes of students. And of course, you charge the students and you make money out of them. Okay? And then we moved to 21 years in some countries, and then we kind of, agreed internationally on 20 years. In Germany, for instance, they have different types of patents. So some are 5-year patents, 7-year patents, So there's a huge debate about what is the right time frame for that. And I don't think that debate will be solved anytime soon. I will just leave you with one other crazy data point. In the US, we give patent protection, we give intellectual property protection in copyright for the life of the author, plus an additional 90 years or 70 years. How does that make sense? The week Michael Jackson died, he made $100 million. His estate did. The Elvis Presley estate still makes around $36 million a year. He's made more money since he died than when he was alive. How does that make sense? So there's a huge debate about the duration of intellectual property protection for the different types of intellectual property rights you have. Yes, sir. You have the last question.
Mine is a small question. If we're equating cash with patents, and I think of cash as the ultimate numeraire that's supposed to hold its value. And whereas your patents seem to want to grow hugely to save all of society, I view cash as sitting here from today on to the next 30 years with its value not changing at all. In which case I would say that patents are not the new cash at all, and thank you for this.
All right, 2 comments. I use the word currency, not cash. And the point I was making is twofold. The first one is that both currency and IP are illusions. They don't exist. We made them up. That just happens to be a fact. We made them up. Now, having made them up, we make money out of them, but there's no physical. What's your physical patent? What does that mean? What's your trademark? What does that mean? We made it up the same way we made up currency. So that was the first point I was making. The second point is we have seen that currency mutates. Remember, one of the earliest forms of currency was barley. We ate it. We have something weird called inflation, so your value changes. What was extraordinarily valuable at one stage in terms of currency no longer is valuable at another stage. So I would say that the 2 points I was trying to make was the nature of the myth, the shared myth that underlines both assets. And I would say that for currency, I would struggle with the idea that a nickel for a movie in the 40s, if you show up at AMC and offer them a nickel now to go into the movie theater, I suspect they will say no. So currency does change in its value.